hang on a second. Gives us a phone.
Councillor Jordan.
Thank you. I wondered, what's your largest facility?
Our largest capacity facility is in Fairfax, serves Fairfax County, Virginia. They are our client outside of Washington, D.C., and it's a 3,000 ton per day facility.
3,000 ton?
How much a year?
3,000 U.S. tons, so that's somewhat less.
1.1, so 2,700.
Can't do that.
2,700.
Who's a
metric tons.
mathematician?
How many a year?
3,000 ton?
3,000 U.S. tons,
Mr. Phillips.
2,700
Mr.
metric
Phillips,
tons.
how many
Yes.
a year?
About 1 million tons a year.
Thank you.
Million
1
ton?
million.
That's an electric generating facility.
That's large. And would you say there's economies of scale by a larger facility? I guess what I'm looking at is what your ultimate
There
plant size.
are notable economies of scale as facility size increases.
So from your perspective, it would be more valuable as the tonnage increased.
Well, for the region's perspective, certainly. It's a bigger opportunity for us, yes. It's also a lower cost per ton option for the region.
I wonder as well, we had someone come out from the labor, and they talked about P3s, public-private partnerships, and spoke about contracts being renegotiated, etc. Has that, obviously you took over some plants. Would you agree with that statement, and what types of things would open up a contract for renegotiation?
Well, typically the type of contract that we've been involved in are the contracts we're discussing here, where we're building a facility and then operating it. And those contract terms are specified and good for the entire term of the agreement. And that has, the idea of a P3 in that sense is to shift the risk and responsibility for cost, environmental and energy performance guarantees and schedule guarantees onto us instead of you traditionally taking them. And that's how it's been structured in most of the agreements that we've been involved with, and that's how this one is intended to be structured.
I thought there was a clause there that spoke about, and I may not have the phrase correct, unforeseen costs. What would you list off as?
Well, this is a typical provision in any contract. If you look at it, a pure public ownership without private sector involvement, the consequence of change in law, for example, war, insurrection, uninsured casualty loss, and that sort of thing, you bear 100% of that. And in this case, we've priced it on the assumption based on what we know today. And to the extent that there is such an occurrence in that going forward, then it would be discussed as to what impact that would be, and there would be potentially an adjustment. But the whole contract wouldn't be reopened.
So changes in provincial or federal legislation would be, in fact, a change of law?
That's, yes. And that's a responsibility you would face in any event.
As well, I wanted to ask the question, the point was also raised on P3s that quite often they can change hands, and you've stated that you did take over some plants in the U.S., so that could be a possibility as well?
Well, the plants we took over in the U.S. were facilities that were so-called merchant facilities. They were simply providing service for a cost per ton. Typically in the facilities, the structures that we're talking about here in Fairfax County, Virginia, all of our Florida plants are like that. There is the client reserves the right to approve that.
To approve the takeover?
or not. And those provisions are specified in the agreement. It's not something we can do unilaterally.
And likely that's appealable?
I'm sorry?
Is there any legal process that...
I'm not sure how the region intends to address that in this agreement, but typically it's their call and their prerogative whether they would allow that, and if they do allow it, it would be certainly on terms that were equal or better to the terms they had with us.
And what if a company faced bankruptcy? We've seen companies in this area that a matter of a few years ago we wouldn't have thought it was possible. So,
well, it's a good question,
that?
and in that case, that's cause for termination under the agreement, termination by the region, and we would be out, and you would be getting another operator.
And as well, if I could ask, who is ultimately liable for any environmental or public health damage?
Well, our obligation, I think I answered this last week, our obligation is to meet the terms of the permit. If we can't, then the regulatory agency has the immediate ability to curtail or even stop operation to prevent that impact.
But if there is a liability issue, who is ultimately responsible?
The liability, if you're talking about, for example, an operating spill or something like that, we would be obligated to do that. We'd be obligated to clean that.
What if I was talking about something bigger than that?
You'd have to give me an example.
I guess obviously it doesn't seem like I'm going to get an answer, so I'll stop.
It's a very broad question. What would you ask me to be responsible for example?
Any environmental or public health impact that may be also unforeseen at this point in time but might occur 10, 15, 20 years down the road.
The agreement is structured and the permitting is structured such that the facility would be curtailed or operations stopped long before that ever presented itself to be a problem. That's how it's structured. That's how all these projects are structured.
And one more question, if I might. The issue's been raised about human biomonitoring. Would you agree with that occurring and perhaps even your employees?
I'm not sure what that means in the context of the agreement that we've been talking to the region about. It's I'm not even sure what it is or how it would be priced.
I think a doctor referred to it as blood tests.
I don't know how to respond to that.
Thank you.